Can a legislator reintroduce the same bill the following year? Well, as the legislature heads into the second year of its two-year session, some legislators may want to reintroduce a bill that didn't make it to the governor's desk during the first year. Are there any applicable rules governing this question? The joint rules of the Assembly and Senate, contained in Joint Rule 54, is titled Introduction of Bills, and Subdivision A discusses the deadline for bill introductions and exemptions from that deadline. Subdivision B concerns when the Assembly and Senate desks are open and what occurs after the printing of a bill. Subdivision C gives us guidance on reintroduced bills. It says that unless approved by the Committee on Rules of the House of Origin, a member may not author a bill during a session that would have substantially the same effect as a bill the member previously introduced during that session. 54C of the Joint Rules goes on to specify that this restriction doesn't apply in cases where the previously introduced bill was vetoed by the governor or its provisions were chaptered out by a later chaptered bill pursuant to Government Code Section 9605. So as a result of this language, a state senator or a state assembly member is prohibited from authoring a bill during the same two-year session that would have substantially the same effect as a bill that the legislator previously introduced during that session. Now, while Joint Rule 54C doesn't define the phrase substantially the same effect, the main limitation set forth is on the bill that was previously introduced. In other words, unless approved by the Rules Committee in the House of Origin, or one of the specified exemptions applies, a senator or assembly member can't reintroduce the same introduced version that was previously introduced earlier in the same session. So it would appear that the language contained in Joint Rule 54C only applies to the introduced version of that bill. That interpretation has been the custom and practice of both the California State Senate and the California State Assembly. So, for example, a legislator could introduce a bill that has been amended one or more times, again, so long as it's not the introduced version. Now, obviously, the first exemption to 54C, prohibited reintroduction, can occur if the Rules Committee for the Assembly, if it's an AB, or the Rules Committee for the Senate, if it's an SB. The second and third exemptions apply to the prohibition for a bill that was vetoed by the governor in the first year, or when the bill's provisions were chaptered out by a later enacted statute. As a result, in those instances, the same bill can be reintroduced by the same legislator if the bill never became law because of either a gubernatorial veto or a chaptering out problem. Now, lastly, if a bill were reintroduced and another legislator wanted to question whether there's a violation of Joint Rule 54C, what does it say? It says that an objection based upon this restriction may be raised only while the bill is being considered by the House in which it is introduced. Upon objection, the chairperson of a committee, if the objection is raised in a committee hearing, or the presiding officer, if the objection is raised on the floor of the House, may rule on that objection. Once the bill passes its House of Origin, however, an objection cannot be lodged in the second House. Note that this objection to the bill may be referred to the Committee on Rules of the House in which the bill was introduced to make that determination, and the Committee on Rules of the Assembly or Senate may obtain assistance from the Office of Legislative Counsel regarding the similarity of a bill